Welcome back. Well, in 2 days' time, we expect the parliamentary panel of 2 judges and 1 advocate to hand over their report on Phala Phala to the National Assembly Speaker, Nkosi. And then we should find out, I imagine pretty soon after that, if they found that there is evidence against President Cyril Ramaphosa that could lead to his impeachment on the grounds of serious misconduct. Ramaphosa has denied breaking the law after US currency was stolen from his farm. It appears he had been holding on to the cash in what appears to be defiance of Reserve Bank regulations. It's also not clear if it was declared to SARS. Modidima Mannya is a legal analyst. He joins us now. Mr. Mannya, good afternoon to you. As I understand it, the panel has to look at the evidence and come to a legal conclusion about whether the president could be found guilty of serious misconduct. How difficult is that? It's a legal conclusion, isn't it?
Yes, but I think the panel's job is very clear and very limited, and that is to assess the information placed before the speaker which constitute the allegations against the president. What the panel basically does is to say there's a face value case that the president must answer, but the panel does not determine whether that is impeachable or not. What it will do, it will say there's a basis for the president to answer. The parliament will have to constitute a committee to conduct an investigation, and in the form that we have seen, for instance, with the public protector. And once that has happened, it will again have to subject that to the National Assembly, which must, by way of a resolution, make a determination whether the president should be impeached or not.
As I understand it, the phrase that is used is serious misconduct. Now, reasonable people can argue about the phrase serious, couldn't they?
Yes, serious misconduct means gross, basically. So it might as well be that there is some basis for misconduct, but not one to warrant an impeachment because it's not serious.
Do you think people are going to end up arguing about that? I sort of feel a bit sorry for the panel. I think whatever they do, people are going to be angry with them.
Well, you know, there's a very straightforward legal test on what would constitute serious misconduct. So the panel wouldn't have a difficulty in defining whether the conduct was conduct on the part of the president which is unacceptable. They will not have difficulty in characterizing it as serious or otherwise. But remember, even their characterization will be dependent on the actual open process that must be conducted. Remember, the committee that will investigate will still have to call witnesses to give evidence. Those people must be cross-examined. The president himself will have the right to give evidence and be cross-examined. So it's actually a bit of a long way to go before you can even reach a conclusion that this is indeed serious. But the legal analysis of what constitutes serious would be if, for instance, there was a serious contravention of the law. So the word serious will always crop up until there's evidence that actually proves the seriousness of the offense.
Normally in a court process, as I understand it, when you present evidence, you have to explain where the evidence came from. It's called chain of evidence, I think. So you have to say this is a video recording, this is where the camera is, this is the date on which the video recording was taken. This is the person who took it, this is how it came to be in the court. In this case, Arthur Fraser gave an affidavit to a police station. Is that enough, or is the panel going to ask someone like Arthur Fraser, how did you get this evidence and where did it come from?
Yes, well, firstly, you can give evidence on what you know, which is first-hand knowledge of the facts to which you are giving evidence to. But you can also give evidence which is called hearsay, which is based on what you were told. That is on condition the people who told you those things will come forward and corroborate what you are saying. Then there's what we call circumstantial evidence, which has to be strong enough to be acted on. Now, in this particular instance, from what it seems is that Arthur Fraser himself didn't have personal knowledge. In fact, if you have regard to what Mr. Paul O'Sullivan has said about some of the allegations made, for instance, there was reference to the cars that were bought, and he seems to be saying, using reverse photography, he has established that the cars were bought long before the alleged theft of the money and all those kind of things. So the evidence has to be interrogated. Mr. Fraser, if he is the main person who makes this allegation, who probably have to take a witness stand and explain even how he got access to the evidence. And there's a very important issue about the admissibility of unlawfully obtained evidence, because some of the evidence might be obtained in contravention of the law. And so all those issues will come into the play, and that will determine ultimately what part of the evidence is going to be admissible. And I suppose that the panel itself will have to make those type of determinations when it determines whether the information that is before it is such that it can be relied upon.
So the panel is not allowed to take oral evidence. So they can only deal with submissions and the evidence, I think, that's publicly available. That means then, unless the evidence that they already have sort of verifies what Fraser has said, it might be quite tricky for them to come to a finding that there is a case. I mean, I might be misunderstanding it, but it might be, unless they're comfortable with the evidence, they couldn't really come to a finding that there is a case against the president. Have I understood that properly?
Yes, look, remember the fact that the panel does not hear oral evidence does not mean that the panel doesn't obtain documents to verify the information before them. But in addition to that, you must bear in mind that once the panel has received the allegations or whatever documents or evidence, they present it to the president to respond. So let's say, for argument's sake, they were to say to him, here's a document that shows that there was a robbery on such a day at your house, and he says, no, there was no robbery on this day, the robbery was on such and such a day, and these are the circumstances, and that tends to contradict what the panel has been given as the basis of the allegations. Then the panel must then determine whether there is a basis. So that type of criteria will be used to verify. So it does not necessarily require oral evidence. For instance, if the police had done an investigation and found that there's no merit in some of the allegations that have been made, and that information is placed before the panel will take that into account.
There are other aspects to this, and it starts to get quite complicated, because it seems to me that the moment the panel makes a finding, I think what's probably going to happen is that they'll give their report to the Speaker. Parliament will probably put out a statement saying, we've received the report, and it seems to me very likely that all of the political parties, or certainly the opposition parties, like the ATM, and it's their motion, will immediately demand to see the findings. Do they have a right to see the findings immediately, or could the Speaker sit on the findings? And I ask this because the Speaker, and I mean, this might be a bit of a conspiracy theory, but the Speaker is a member of the African National Congress, and the African National Congress, as I think you know, is going to go to a conference. So do you expect her to make the findings public virtually immediately?
Well, let me answer it in this way. Remember when the Speaker granted the panel an extension, there was a big uproar. And in the week that she granted that postponement, there was a programming committee of the National Assembly. And my understanding is that the programming committee took a decision that the motion would be debated, I think, on the 13th of December. And with other matters that the term of the National Assembly was extended. I think the National Assembly was meant to rise on the 1st. And it will now do that after the 13th. So any suggestion of a conspiracy would be defied by that reality that the motion or the matter will be debated. So, and for that to happen naturally, once the Speaker receives the report, she would have to table it in the National Assembly. It becomes onto the order paper. The members of the National Assembly, not just political parties, have access to the documents which are going to form the subject of a discussion and debate. So I don't even think the question of the conference and the Speaker being the member of the ANC features here, as the Speaker. She's going to have to follow the procedure, and the programming committee, as I understand, has already agreed. Okay.
And then during Nkandla, I mean, there's some resonances with what happened with Nkandla. There's some very big differences too. But with Nkandla involving former President Jacob Zuma, the National Assembly, or the ANC MPs on the National Assembly, basically voted to, I think the right word would be to shield the then President Zuma from any kind of impeachment or action. Can the National Assembly do the same now, even after the Nkandla judgment, which said Parliament's actions had been wrong?
I wouldn't want to use the word shield. you know what we must understand, Stephen, is the type of framework that we have. We have a party political system. People who are in the National Assembly from all political parties are given a mandate by their parties. I still want to come across one political party which can say, we said to our MPs or MPLs or councillors to follow their conscience. You saw what happened, for instance, in the city of Johannesburg when a motion of no confidence was passed against the mayor. And the various coalition partners went very harshly on the members who voted according to their conscience or who didn't toe the party line. And I think that is the situation that involves a party political system. So whether we ultimately call it shielding or not is something else, but I assume each of the political parties will in their caucus take a position about how they are going to respond to the outcome. Let's say, for argument's sake, the panel finds that there's not even the slightest chance that the president committed any form of misconduct. I have no doubt that the political parties which have been calling for this will most likely take a view contrary to the views of the panel, and their caucuses will take that decision. There are those parties who will say, well, we thought there was a case, well, we are giving up, we don't think there's a case. So it's a party political system. I expect the ANC to obviously meet as a caucus and take a position, whatever the outcome is. If, for instance, the outcome were that there's no case, the ANC caucus might say, well, here's an opportunity to demonstrate to South Africans that people are just attacking us. If the panel says there's the prima facie case, the ANC might say we want to consider what the implications are and decide that the motion will be debated next year.
Modidima Mannya.
It's a game of numbers, by the way.
Yeah, isn't it always? Modidima Mannya, thank you very much indeed. Really appreciate the time.